California Senate Bill 9 was signed into law by Governor Newsom on September 16, 2021, and took effect on January 1, 2022. Subject to certain requirements, Senate Bill 9 allows ministerial, staff-level building permit, approval of a proposed housing development containing no more than 2 residential units, for example, 1 duplex or 2 detached single-family homes, in single-family residential zones or a subdivision of 1 single-family residential lot into 2 lots. In most circumstances, Senate Bill 9 will result in the potential creation of 4 dwelling units from an existing single-family parcel, generally in the 4 simplified scenarios depicted below. In comparison, a single-family property is currently permitted 3 units, inclusive of a single-family dwelling, an ADU, and a junior ADU. Step 1. Confirm the project is eligible. Projects for a 2-unit development and/or an urban lot split must meet all the criteria on the respective Senate Bill 9 eligibility checklist to qualify for ministerial review. A project that includes a proposal for a 2-unit development and an urban lot split must complete both checklists. Senate Bill 9, 2-unit development eligibility checklist. Senate Bill 9, urban lot split eligibility checklist. Important note: Senate Bill 9 only applies to single-family residential zones. Step 2. Submit a complete Senate Bill 9 application packet. If you determine your project is eligible, you may apply for the Senate Bill 9 2-unit development and/or the urban lot split using the Universal Planning application. In addition, the following forms are also required for a complete application: Owner Occupancy Affidavit, Prior Tenancies Affidavit, Draft Deed Restriction for 2-unit development, Draft Deed Restriction for urban lot split. Additional information on subdivisions. You will need to hire a licensed surveyor or engineer to prepare a tentative parcel map and illustrate compliance with the Subdivision Map Act and the Milpitas City Code. Chapter 1 Subdivisions. Tentative map submittal requirements. Tentative subdivision map. See the Universal Planning application for submittal details on tentative parcel maps. Note: a maximum of 2 units of any kind, primary dwelling, ADU, or junior ADU, on each of the 2 resulting lots from an urban lot split are allowed. An ADU/junior ADU is not permitted when the lot is split, and 2 primary units are developed on each lot. Step 3. Timelines for ministerial review. 1. Completeness and eligibility review. The city will issue a determination of completeness and eligibility within 30 days of receipt of an application. 2. Action on the application. City staff will issue an approval or denial on the application within 60 days of the completeness determination. Step 4. Submit for building and/or engineering approvals. Following project approval, permits including building permits and encroachment permits are applied for and reviewed. What is the city doing? On December 14, 2021, the City Council adopted an urgency ordinance to implement Senate Bill 9 before the law went into effect on January 1, 2022. The urgency ordinance and associated staff report may be viewed at the links below. City of Milpitas Agenda Report. Item title: Conduct a public hearing and consider adopting Urgency Ordinance Number 38.844 amending sections of Chapter 1 Subdivisions and Chapter 10 Zoning of the Milpitas Municipal Code relating to urban lot splits and to unit projects to comply with Government Code Sections 66,411.7 and 65,852.21 and determining the ordinance to be statutorily exempt from CEQA. Staff contact: Ned Thomas, 408-586-3273. Category: Public Hearings Community Development. Public Hearings Community Development. Meeting date: December 14, 2021. Staff contact: Ned Thomas, Planning Director, 408-586-3273. Recommendation: 1. Conduct a public hearing and move to close the hearing following comments. 2. Adopt Urgency Ordinance Number 38.844 amending sections of Chapter 1 Subdivisions and Chapter 10 Zoning of the Milpitas Municipal Code relating to urban lot splits and to unit projects to comply with Government Code Sections 66,411.7 and 65,852.21 and determining the ordinance to be statutorily exempt from CEQA. Background: Governor Newsom signed Senate Bill 9 on September 16, 2021, establishing a 2-pronged approach to require increased housing density in single-family residential zones. First, if certain conditions are met, Senate Bill 9 requires ministerial approval of up to 2 units on a lot in single-family residential zones. The units may be in one structure or 2 separate structures. Second, the statute requires ministerial approval of lot splits in single-family residential districts, subject to similar conditions. Eligible single-family lots may be split, roughly into halves, with resulting lots as small as 1,200 square feet. If the conditions are met for both approvals, the applicant could build at least 4 units on what was originally one single-family residential lot. No public hearing is required for these ministerial approvals. Many cities across the state are considering the adoption of urgency ordinances to amend local subdivision and zoning regulations to comply with state law before the new legislation takes effect on January 1, 2022. Future refinements to the state legislation are expected. On November 29, 2021, the Planning Commission held a special meeting and conducted a public hearing to consider the proposed city-initiated amendments to the subdivision ordinance and zoning ordinance. The Commission voted 5-1, Tau, nay, 1 vacancy, to adopt Resolution No. 2-1-0-5 recommending that the City Council approve zoning text amendment ZA21-0004 amending sections of Chapter 1 subdivisions and Chapter 10 zoning of the Milpitas Municipal Code to modify or add regulations relating to urban lot splits and to unit projects to comply with Government Code Section 65,852.21 and 66,411.7. Analysis. The proposed zoning text amendments would amend sections of Chapter 1 subdivisions and Chapter 10 zoning of the Milpitas Municipal Code, MMC, to comply with Government Code Sections 66,411.7 and 65,852.21. The proposed amendments would modify the Milpitas Municipal Code to appropriately regulate urban lot splits and to unit projects under Senate Bill 9. Specifically, the amendments would make the following modifications. Amends Title 11, Chapter 1 Subdivisions, Section 3 Definitions of the MMC to add a new definition for urban lot split as subsections I-1-3-09. Amends Title 11, Chapter 1 Subdivisions of the MMC to add a new subsection XI-131 to allow and appropriately regulate urban lot splits in accordance with Government Code Section 66,411.7. Amends Title 11, Chapter 10 Zoning, Section 2.03 Definitions of the MMC to add new definitions for urban lot split and to unit project to the zoning ordinance. Amends Title 11, Chapter 10 Zoning, Section 4 Residential Zones and Standards, of the MMC to add a new subsection XI-10-4-08 to allow and appropriately regulate to unit projects in accordance with Government Code Section 65,852.21. The proposed amendments are consistent with Milpitas' general plan policies to facilitate new housing production and provide for a variety of housing types and densities that meet the needs of individuals and families. Proposed amendments to Milpitas Municipal Code. Senate Bill 9 allows a local agency to impose objective zoning and design standards so long as those standards would not physically preclude the construction of up to 2 units at least 800 square feet in floor area on a single-family lot. Senate Bill 9 also requires a local agency to grant ministerial approval of a parcel map for an urban lot split in a single-family residential zone if it meets certain requirements, including a minimum lot size of 1,200 square feet and other objective zoning standards, objective subdivision standards, and objective design standards, unless those standards would physically preclude the construction of 2 units at least 800 square feet in floor area on either of the resulting parcels. The proposed zoning text amendments would amend the city's subdivision regulations to allow urban lot splits consistent with the provisions of Senate Bill 9 and establish objective standards to regulate the subdivision of parcels and the development of new 2-unit projects on residential parcels within the city. Establishing these regulations will result in the orderly subdivision and development of parcels. The requirements of Senate Bill 9 related to urban lot splits will be addressed in additions to MMC Title 11, Chapter 1 Subdivisions. Specifically, the proposed zoning text amendments include the following changes. 1. Add new subsections I-1-3-09 to establish a definition for urban lot split. Under Senate Bill 9, local agencies must grant ministerial approval of certain subdivisions of one lot into 2 without discretionary review or a hearing. To qualify for ministerial approval under Senate Bill 9, the proposed lot split must satisfy certain criteria. The establishment of this definition aids in the regulation of parcel maps for urban lot splits consistent with the requirements of Government Code Section 66,411.7. 2. Add new section XI 131 to allow and appropriately regulate urban lot splits in accordance with Government Code Section 66411.7. The proposed zoning text amendments would amend the city's zoning regulations to provide directive language regarding certain subdivisions and establish objective zoning standards, objective subdivision standards, and objective design review standards. 3. Add new definitions to subsections I10, 2, 03 to establish definitions for urban lot split and twin-it project to implement Senate Bill 9. Under Senate Bill 9, local agencies must grant ministerial approval of certain two-unit projects on one single-family residential lot without discretionary review or a hearing. To qualify for ministerial approval under Senate Bill 9, the proposed two-unit projects must meet certain criteria. The establishment of these definitions will aid in the regulation urban lot splits consistent with the requirements of Government Code Section 66411.7 and two-unit projects in accordance with Government Code Section 65852.21. 4. Add new subsections I1, 4, 08 to allow and appropriately regulate two-unit projects in accordance with Government Code Section 65852.21. The proposed zoning text amendments would amend the city's zoning regulations to provide directive language regarding certain aspects of two-unit residential development and establish objective zoning standards, objective subdivision standards, and objective design review standards. General Plan Conformance. The city's general plan is the primary long-range planning document that provides the vision for the future growth and development of Milpitas. The proposed urgency ordinance conforms to the policies and standards in the city's general plan, as summarized in Table 1. General Plan Consistency. Finding for approval. A finding is a statement of fact relating to the information that the council is considered in making a decision. Findings shall identify the rationale behind the decision to take a certain action. The following are the required finding for approval of a zoning ordinance text amendment. Zoning Amendment, MMC Sections I10, 5702 G 3. 1. The proposed amendment is consistent with the general plan. As summarized in Table 1 above, the proposed zoning text amendments include amendments to the city's subdivision and zoning regulations that are consistent with the Milpitas general plan. Specifically, the proposed amendments implement Policy 1.4 of the Land Use element and Policy 4.1 of the Community Health and Wellness element, which speak to the need to provide a variety of housing suited to a range of household types, for example, individuals, families, and income levels, and create housing in close proximity to public transportation. The zoning amendments would also help to realize the intent of Goals C and D of the housing element, which call for the city to facilitate new housing production and support diversity and affordability in Milpitas housing stock. Adoption of the proposed amendments to the zoning ordinance would make it easier, faster, and more cost-efficient for property owners to create new single-family residential units on smaller lots, and the new units are likely to be more affordable. Adding missing middle housing types within the city's existing neighborhoods would greatly help to meet local housing demand, especially for smaller households with lower to moderate incomes such as students, single working individuals, and seniors. 2. The proposed amendment will not adversely affect the public health, safety, and welfare. The proposed zoning text amendments include amendments to the city's subdivision and zoning regulations that will provide a streamlined ministerial review and approval process for qualifying projects. The amendments also add new regulations specific to urban lot splits and two-unit projects to ensure that future units are compatible with surrounding single-family residential uses and avoid potential impacts, for example, to privacy and solar access on adjacent properties. Policy alternatives. Alternative 1. Do not amend sections of Chapter 1 subdivisions and Chapter 10 zoning of the Milpitas Municipal Code relating to urban lot splits and two-unit projects to comply with the provisions of Senate Bill 9. Pros. The city would not be required to consider future amendments if the legislature makes future changes to Senate Bill 9. Cons. The city would only be able to require Senate Bill 9 projects to comply with the limited requirements in Senate Bill 9. Therefore, the city would be limited in its ability to regulate Senate Bill 9 projects, which will potentially result in parking, privacy, and visual impacts to single-family neighborhoods. Reason not recommended. Without an ordinance establishing local requirements for urban lot splits and two-unit projects, the city would only be able to implement the limited requirements in Senate Bill 9. The proposed amendments are intended to protect neighborhood character and address the property rights of Milpitas residents who live in single-family neighborhoods. Fiscal impact. Senate Bill 9 requires local jurisdictions to approve certain proposed lot splits and two-unit projects, beginning in January 2022. In Senate Bill 9 lot split followed by in Senate Bill 9 two-unit project on each of the two new lots would result in 4 total dwellings on what was originally one single-family lot. The actual number of property owners who may choose to take advantage of this new development potential is unknown, but the new regulations create the potential to significantly increase the number of residential units requiring city services and increasing costs. On the other hand, the construction of additional units could also generate new fee revenue. The full fiscal impact of allowing urban lot splits and two-unit projects is unknown at this time. California Environmental Quality Act. Under California Government Code Section 65,852.21 J and 66,411.7 N, the adoption of an ordinance by a city or county implementing the provisions of Government Code Section 66,411.7 and 65,852.21 and regulating urban lot splits and two-unit projects is statutorily exempt from the requirements of the California Environmental Quality Act, CEQA. Therefore, the proposed ordinance is statutorily exempt from CEQA in that the proposed ordinance implements these new laws enacted by Senate Bill 9. Planning Commission action. The Planning Commission considered the proposed zoning text amendment, including text amendments to the city's subdivision ordinance and zoning code, at a special meeting on November 29, 2021. Following public comment, the Planning Commission adopted Resolution Number 210-5, Attachment A, by a vote of 5-1, Tau, nay, 1 vacancy, recommending that the City Council adopt an urgency ordinance amending sections of Chapter 1 Subdivisions and Chapter 10 Zoning of Title 11 of the Milpitas Municipal Code relating to urban lot splits and two-unit projects consistent with the provision of Senate Bill 9. Recommendation 1. Conduct a public hearing and move to close the hearing following comments. 2. Adopt Urgency Ordinance Number 38.844 amending sections of Chapter 1 Subdivisions and Chapter 10 Zoning of the Milpitas Municipal Code relating to urban lot splits and two-unit projects to comply with Government Code Sections 66,411.7 and 65,852.21 and determining the ordinance to be statutorily exempt from CEQA. Frequently asked questions. What is Senate Bill 9? Senate Bill 9 is a new law enacted by the state of California that increases the allowed density on certain single-family lots. Senate Bill 9 adds two new sections to the Government Code, 65,852.21 and 66,411.7, that make it easier to add a second single-family residence or split an existing lot, urban lot split, in areas which meet the requirements. Can I use Senate Bill 9 to split my parcel? Senate Bill 9 urban lot splits are subject to the same restrictions set forth in the preceding FAQ. See Government Code Section 66,411.7. If a parcel has some of these restrictions, please meet with a planner to determine the applicability of Senate Bill 9. Senate Bill 9 requires that each resulting lot be at least 1,200 square feet. A parcel may only be subdivided using Senate Bill 9 one time. That is, the two parcels resulting from the urban lot split may not be further subdivided pursuant to Senate Bill 9. Can I rent out the units created by and Senate Bill 9 project? Applicants for an urban lot split under Senate Bill 9 must sign and record a deed restriction that they will use one of the units as their primary residence for a minimum of 3 years. Otherwise, units may be rented, but for terms of at least 30 days, no short-term rentals. Does Senate Bill 9 apply to homeowners associations, HOAs? Senate Bill 9 does not address rules or restrictions implemented and adopted by homeowners associations or included in CC&Rs, covenants, conditions, and restrictions. The city does not enforce private CC&Rs. How does the permit streamlining ACT apply if these are ministerial actions? Senate Bill 8, also effective January 1, 2022, extends the requirements of the Permit Streamlining Act to housing projects of one unit or more that require no discretionary approvals. As a consequence, Senate Bill 9 projects are subject to the Permit Streamlining ACT's requirements for completeness determinations, within 30 days of submittal, and approval deadlines, within 60 days of determining that the project is exempt from CEQA. Can I partially or completely demolish an existing dwelling for by Senate Bill 9 project? You may not demolish the dwelling if it is rent-controlled, subject to affordable housing restrictions, or a renter was evicted from the dwelling in the past 15 years. You may not demolish more than 25% of an existing dwelling's exterior walls if the dwelling has been a rental property in the past 3 years. Senate Bill 9 An accessory dwelling unit, ADU. One attached or detached ADU may be permitted on a single-family lot that has not been subdivided pursuant to Senate Bill 9. An ADU is not permitted on an Senate Bill 9 subdivided lot. Additional information on requirements for ADUs can be found in Milpitas City Code, MMC, Sections I-10-1308. In addition to complying with the design and development standards outlined in the Senate Bill 9 to UNIT objective design standards outlined in the urgency ordinance, and pursuant to MMC, Sections I-10-1308, streamlined accessory dwelling units, the maximum floor area allowed for the accessory dwelling unit shall be 800 square feet, the side and rear yard setbacks are at least 4 feet, and the maximum height shall be 16 feet. Senate Bill 9 and Junior ADUs. One junior ADU may be permitted on a single-family lot that has not been subdivided pursuant to Senate Bill 9. A junior ADU is not permitted on an Senate Bill 9 subdivided lot. Additional information on requirements for junior ADUs can be found in MMC, Sections I-10-1308. In addition to complying with the design and development standards outlined in the Senate Bill 9 to UNIT objective design outlined in the urgency ordinance, and pursuant to MMC, Sections I-10-1308, junior ADU standards, the junior ADU unit must be constructed within the existing walls of an existing or proposed residential dwelling, that is, one detached single-family home or one of the duplex units. Pursuant to MMC, Sections I-10-1308, the maximum floor area allowed for the junior ADU shall be 500 square feet. Pursuant to MMC, Sections I-10-1308, a recorded deed restriction will be required stating that the owner shall reside in one of the units constructed on the property. Note: an ADU/junior ADU is not permitted when the lot is split pursuant to Senate Bill 9.